All right, here we are in the amendments. There's lots of these to read and lots to go through. We'll go through quickly. Some of the stuff we may skip over a little bit, but we're going to learn these. Now, the first of these are called the Bill of Rights. Now, these Bill of Rights were actually passed when the Constitution was ratified in 1791. You can see they all passed on the same day. These first 10 all came together. Now, that was because there were some people, when they looked at the Constitution, that were a little bit concerned that there weren't enough protections against the government. They wanted to make sure that people had certain rights that the government could not take away. And so they added these amendments very quickly to the Constitution just to write them in right from the start. So let's look at them. Amendment number 1, one of the most famous. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Now, let's look at this. Who does this limit? This limits Congress. It says, Congress shall make no law to establish religion or to prohibit the free exercise thereof. Now, a lot of people say, the phrase separation of church and state, and now that tells you that there are certain things that the people can't do. Well, separation of church and state, that phrase never happens in the Constitution at all, anywhere. That was made up later. It was actually Thomas Jefferson in something that he wrote used that phrase. But people use that all the time now to limit what people can do, what type of religious things you can do in public settings. But that is not because of this First Amendment. The First Amendment just says that Congress can't make any laws. That's it. It doesn't say people can't pray. It doesn't say people can't put up 10 commandments or crosses or wear whatever religious things they need to wear. That's not what this says. This just says Congress can't make any laws establishing a religion or stopping people from exercising their religion. That's it. Let's see, and we're going on, or abridging the freedom of speech, or of the press, or of the right to people to peaceably to assemble, and to petition the government for a redress of grievances. So these are all things that happened, all things that were tools of the revolution, the freedom of speech, the freedom of press, to be able to protest and petition the government for the grievances. These are all things that they did, all tools that they used in the revolution. They wanted to make sure that those tools were never taken away from the people. So we can still speech and we can still, publish whatever we want, and we can peaceably protest our government. Going on, Amendment number 2, the right to bear arms. So a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So as you look at these, you do have to remember that there is the reason. Here's the reason. A well-regulated militia being necessary to the security of a free state. That's their reason. Because of that, the right of the people to keep and bear arms shall not be infringed. Even though this is part of the Constitution, it's not really a part of the law. The law is right here. The right of the people to keep and bear arms shall not be infringed. But sometimes the founders just like to put in reasons. Here is our reason. Now, whether that reason is still valid or not, or whether that reason still counts or not, it doesn't change the law. In other words, you can keep guns besides, even if you're not part of a militia, you still have the right to keep and bear arms because this is the law, not this. So keep in mind as you read some of this that sometimes there's a reason and then the law. And the reason helps us understand what they were thinking, but it isn't the law itself. So let's go on to number 3. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So we can't, the government can't force soldiers to come live in your house, which is nice. Now remember, this is a direct reference to Boston when they were having the king was making the soldiers live in the Boston homes, and the people didn't like that. So that's a direct result of those type of laws. Let's go up here, number 4. Search and seizure. This is when you talk about right to privacy. This is the right to privacy. Amendment. So the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So in other words, nobody can just come in and search your stuff. The government can't just come and say, we want to look through your papers, we want to look through your house, we want to do it. You can't do that. You can't just go in and start looking through people's stuff. And no warrant shall be issued but upon probable cause. I'm going to do that, underline that, probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So when cops want to come search your house, they have to give a judge a reason. This is why we need to search the house. And they have to say exactly the place to be searched and the things that they're looking for. So in order for them to search your house, they have to have those three things. And then the judge can give them a warrant to come search your house. But before that, they can't search your house. Now, this has come up a little bit recently as people, tap into your internet and read your emails and the government listening to your phone calls. Some people say that is not allowing people to be secure in their persons, that is unconstitutionally searching people's things. So there's a little bit of a debate and controversy going on right now about what the government can and can't do, especially when it comes to telephones, cell phones, internet, text messages, emails, things like that. Right off the bat, it's still pretty clear that you cannot go into people's houses and search their stuff, but can you search their internet stuff or their cell phone stuff? That's one of those questions right now that's a little bit up in the air, because we know the government does tap and listen to, trying to look for terrorists. And they do go through people's emails, and they do search telephone calls. And so some people are saying, hey, you're breaking the Fourth Amendment. But some people are like, no, because we're not going into your house. So that's a controversial one right now that still, I think, is not quite exactly been solved on there's still people who think that the government is doing things that they shouldn't according to the Fourth Amendment. Amendment number 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases so you always have to, you can't go to trial until you've been indicted. And what it means to be indicted is that the people look at the evidence against you and see if there's even enough evidence to go to trial. Is it even worth trying to go to trial? Do they have enough to even suspect you? So that people can't just, throw you in jail and start trying you for things like for silly reasons. You have to actually be indicted. A judge actually has to say that, nope, there is enough stuff here that we should have a trial to see if you're guilty. There are exceptions to that. In the land or naval forces, so in the military they don't need a grand jury. Military courts are completely different. Or in the militia, when in actual service in time of war, public danger. So military courts are completely different than normal courts. And the Constitution allows for that military courts can be different. Nor shall any person be subject for the same offense to be twice put in jeopardy of life, limb. So this is the double jeopardy clause, and I want you to make sure that you do that. What is double jeopardy? Double jeopardy is when you go to trial more than once for the same crime. So let's say somebody, I think you killed somebody, we're going to take you to trial. They take him to trial and he's found innocent. Then they say, well, we're going to do another trial to see if you're guilty. You can't do that. You cannot take somebody to court twice for the same thing. Once it's decided, it's decided. You can appeal and go to a higher court, but you can't keep bringing them to jail and keep trying them for the same thing. So, nor shall be compelled in any criminal case to be a witness against himself. So when people say, I plead the Fifth, what are they talking about? They're talking about the Fifth Amendment here, which means that you cannot be compelled to witness against yourself. And otherwise, you can, if people ask you questions about the crime, you can just be quiet. You don't have to answer questions about a crime you're accused of, because you cannot be compelled to be a witness against yourself. So when they say you have the right to remain silent, that is your right. It's the Fifth Amendment right that you don't have to witness or talk about your crimes you've been accused for. And nor can they be deprived of life, liberty, or property without due process of law. So, you know, you can't just have laws that take stuff away unless they've been convicted of something. Nor shall private property be taken for public use without just compensation. So if the government does take your land, which they can, it's actually legal for the government to come take your land away from you, but they have to pay you for it. They can't take it for free. They can force you, in other words, to sell your property to them, but they can't take it for free. They have to pay you for it. So, trial, punishment, compensations for taking. Fifth Amendment, important one that you hear referred to a lot, especially in the right to remain silent. Amendment number 6, the right to a speedy trial and confrontations of witnesses. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of his peers, of the state and district wherein the crimes have been committed. So that's the people that live around you. Now this is because, remember, they had the crimes like for the Boston Massacre where they wanted, or in the Boston Massacre, didn't end up this way, but other ones did, where they would take the soldiers, the British soldiers, and they would take them back to England to try them for crimes, and the people in England were nicer to them. So they're like, no, you need to have the trial where the crime took place. Which district shall have been previously ascertained by law to be informed of the nature and cause of the accusation to be confronted and to be confronted with the witness against him, and to have compulsory process for obtaining witness in his favor, and to have the assistance of counsel for his defense. So when you go to trial, you actually have, if you're accused of a crime, you have the right to a speedy trial, to have an impartial jury, and you need to be informed of what you're accused of. They can't just say, we're accusing you of a crime, we're not going to tell you what it is. No, they have to tell you exactly what they're charging you for, and to be confronted with the witness. So who's ever accusing you of the crime, you have a right to be confronted with them, to see the witness. And you have compulsory process for obtaining witnesses. So in other words, this is, you have the right to call people to court to say good things for you. If there's people that know you didn't do it, then they can be compelled or kind of forced. This is a subpoena. They can be forced to court to tell the court that you didn't do it. So if somebody knows you didn't do it, they can't hide and say, I'm not going to come testify. No, you can compel them to come testify in your behalf. And to have the assistant of counsel for his defense. So you have the right to an attorney. If you can't pay for an attorney, then the government will give you one. So you will have an attorney to help you. You don't have to do the trial all by yourself. You have a right as a U.S. citizen to have an attorney there with you. And if you can't afford an attorney yourself, the government will give you one because the Constitution says it has to. Going on, so those are some more of if you're accused of a crime, things. Trial by jury in civil cases. In suits at common law, where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined by a court of the United States than according to the rules of common law. This talks about a little bit about small claims court. There is such a thing called small claims court, which states can run, and small claims court is not when you're being convicted of a crime to be put in jail, but it's when you're arguing with your neighbor or somebody you did business with and they stole money and you want to get the money back. Things like that, where you don't have the power to put somebody in jail, but you do have the power to get your things back. Small claims court is part of that. And I know in Utah, small claims court is anything less than $10,000. All the states different a little bit. But if it's less than $10,000, there isn't a trial by jury. There's just a trial by a judge. A judge just decides with common law. And common law is just kind of the common sense rules of decency and what's right and what's wrong. It doesn't have to follow exactly any laws that have been written. They can just be laws that are understood. So small claims court, a judge can do it. You get some of these on TV, right? With, People's Court and Judge Judy or whatever. I don't even know which ones are on right now. I think those are the ones when I was a kid. But small claims court where one judge can just decide who's right and who's wrong and who owes somebody else money. If it's less than $10,000, you can do it that way in the state of Utah. You can just do small claims court. Number 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So that's the cruel and unusual punishment one. That's why you don't have torturing as part of your penalty if you do a crime. That is not, the Constitution says you can't do that. Number 9, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So this one is just saying, even though we have these lists of rights, these 8 amendments up here that have rights, that doesn't mean they're the only rights. There are other rights people have too. For instance, the right to breathe. You probably have the right to breathe. Even though we didn't put it in the Constitution. Now that's a silly one, but you get the point, right? There's other rights that people have, and we didn't write them all down, so just because we wrote some of them down doesn't mean that there aren't other rights that people should have. There. Number 10, the last one in the Bill of Rights here. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved for the states, respectively, or the people. So the Constitution says there are certain things that government can do, and there are certain things that government can't do. And there are certain things that the states can do, and there are certain things that the states can't do. So certain things that federal government can do, certain things it can't. Certain things that state governments can do, and certain things it can't. That's what the Constitution says. Now, if the Constitution doesn't say anything about it, there's lots of things that the state Constitution doesn't mention. There's thousands of things that the Constitution just doesn't even bring up. It's not an issue. So, if the Constitution doesn't talk about it, who's in charge of it? Then it's the state or the people are in charge of it, not the federal government. For instance, what are some of these? For instance, schools. Nowhere in the Constitution does it talk about schools. So who's in charge of schools? Not the federal government. The states are in charge. What also about, here's a recent one that people are talking about, what about health care? Health care is not talked about in the Constitution. So who's in charge? The state or the people are in charge of it, not the federal government. Now, but President Obama just passed this big health care bill. How can he do that? Well, they say that it's either under the Interstate Commerce Clause, where federal government is in charge of anything that happens between states. They're like, well, health care, that happens between states, so we're in charge. Or the General Welfare Clause, that government is in charge of just making sure that people are generally well-fared, that they are faring well. So there's a little bit of an argument right now on this one, and that one's actually going to the Supreme Court right now. The states are suing the government saying, hey, the Constitution does not give you the right to do health care, so it's the states that are in charge. So this issue right here is actually being taken to the Supreme Court right now, and the Supreme Court will decide whether federal government can do health care or laws or not, because the Constitution doesn't say anything about health care specifically, but it does say things about interstate commerce, and it does say things about general welfare. So that one's one that's a little bit of a controversy right now. All right, so there are the first 10 amendments to the Constitution.